This is the Financially Simple Podcast, the show dedicated to destroying the complexities of money for today's small business owner. The content in the show is for informational purposes only. This show is not investment advice. Instead, seek help from a competent financial advisor or conduct your own due diligence. Justin Goodbread, CFP, is an investment advisor representative of Heritage Investors, a registered investment advisor only conducting business in states where it is properly registered or is excluded or exempted from registration requirements. Registration is not an endorsement of the firm by securities regulators and does not mean the advisor has achieved a specific level of skill or ability. Here's your host, pizza-loving, certified financial planner, Justin Goodbread.
And welcome back to the Financially Simple Podcast. I'm your host, Justin Goodbread, and today we're going to dive into the weeds. We're going to deal with the exhaustive list of trust used for planning. That's today's topic. Now, we've spent some time in the last episode talking about the basic categories of trust. Today, I'm going to cover the 39, yes, you heard me right, 39 most common trust used in planning. This is an exhaustive list. This is not intended to be advice by no means. More importantly, I want you to realize that a good planner, and a good planning attorney working with the planner, and a good CPA who understands income tax planning and estate planning, if you put all three of those together, there is a powerful mix. You're probably going to hear some things today that you're like, Justin, I didn't know those existed. Yeah, there's a lot that we don't know in the areas of the fields we don't specialize in. I was fishing in West Virginia this last weekend with my son and a couple of clients. And as we were fishing on this river that I've been down many times with a group of friends and clients, I learned about a new fish that I had never seen before. It's called a tiger muskie. Now, I've fished all over the country. As you may know, I love to hunt and fish. It's just one of those things that I think if you're born in the sticks in South Georgia, you have to learn how to hunt and fish. And I've fished this river countless times, and I've caught all sorts of fish. But I had never heard of a tiger muskie. It was unbelievable to see this fish. And I didn't catch one, but I got to see it pretty close. Even though I have fished, and I would consider myself a decent fisherman, I'm by no means a professional, but I've caught hundreds, if not thousands of fish in various waters, in various states, in various oceans, literally, around the world. I would consider myself a pretty decent fisherman. But in a small river that I had been down many, many, many times, I didn't know about one fish that I saw. I was like, man, what in the world is this? So I want you to take the same approach. Today's going to feel like we're in the weeds a little bit, and that's okay. I'm going to try to keep this super simple, so I've developed some very short, simple definitions, and I'll try to give an example for each of these types of trust. But more importantly, I want you to think about your particular situation. You're a business owner. I get it. I was talking to a business owner today that's probably going to gross somewhere north of $100 million of revenue. You're like, dude, Justin, do you only work with the super affluent? No. I just was somebody else speaking with that's going to hire a firm to help them prepare the value of their business and to ultimately manage their financial life because they go one in hand. At the same time, I spoke to somebody this morning who's just getting started in business that our team is going to help them. Even this individual who is starting or the one who's been around business for a while, as I was talking through some of these things, they're like, Justin, I've never heard of that before. So I want you to take that backdrop and let's deal with today's episode. Let's deal first of all with the most common types of trust. The first is the revocable living trust or the revocable trust. Now, we talked about it last time. It's perhaps one of the most popular trusts out there. I'm not going to deal with it anymore. Basically, it allows you to make changes while you're still alive. That's the idea in a nutshell. The next one is what's called a grantor trust. And basically, a grantor is the individual who creates a trust. It allows them to place money or assets or whatever it is into a trust to streamline things. It's called a grantor trust. Pretty basic, nothing major there. The third we talked about last time called an irrevocable trust. An irrevocable being opposite of a revocable or revocable trust, meaning that once you place money into the trust, you're stuck. You can't change it. There are many irrevocable trusts that we're going to go over today. And there's many revocable trusts we're going to go over today. Remember, those are the basic categories. We also talked about a testamentary trust. A testamentary trust is created by the will the majority of times. It specifically outlined what assets are going to be utilized at the time of the death of the grantor. So it's called testamentary trust. Again, most of the time it is explicit instructions in a will of the deceased individual, which is why You may say, well, Justin, I'm just going to go to LegalZoom, which is a great company, and get a will. You may need more than LegalZoom. You just may. So a testamentary trust could create some problems tax-wise for your business if you're not careful. Now, we talked about this in jest, but the fifth type of trust is what's called a minor's trust. Basically, it passes assets to a child who is under the age of 18. Now, if you'll remember about 3-4 episodes ago, we were talking about this will and what happens if I pass away and I leave assets, whether it be life insurance, et cetera, to my children who are under the age of 18. Well, the minor's trust is there to gather those. Typically, a minor's trust is put in place before you pass away. It can be part of the testamentary process. It can go in that area. But nonetheless, it's there basically to provide monies for a minor with a trustee who's going to distribute those monies for your particular purposes. Number 6 is what's called a spendthrift trust. Some people call it the beneficiaries trust or the separate shared trust is a term I heard not too long ago in an estate course I was taking. But nonetheless, it's a spendthrift and allows you to protect that individual who may not be really good with money. I mentioned in the last episode about a client whose child is dealing with some addiction issues. A spendthrift trust will allow you to protect the assets from the creditors of this particular child or any other issues they may be dealing with. We all deal with life. Now, number 7 is one you may have heard of. I heard it on Law and Order the first time I heard this, called a blind trust. Like an individual who can't see, a blind trust. Basically, a blind trust allows the trustee or anybody who's holding a power of attorney to handle assets of the trust without the knowledge or without the beneficiaries knowing about it. It's really amazing that you can use this trust. Basically, you can create a trust and the beneficiaries not know about who the trustee is, who is managing the assets, what the provisions are. There's a number of ways it can be drafted depending on the state that you're in. The idea being is it's going to prevent contention amongst beneficiaries. It's really a good way to keep the family unit together. Number 8 is what's called a discretionary trust. A discretionary trust, the beneficiaries and the assets are not constant. They're not fixed, but they're determined by a certain criteria that is used in the trust document, and it gives discretion to the trustees to decide who the beneficiaries will be, which assets will be included in the trust, etc. So it can be adjusted in nature. So it's called a discretionary trust. Now, those 8 types of trust are the most common, pretty simple types of estate planning documents. Have you learned anything yet? It's fixing to get fun. Yes, I said fixing. That's what we say in the South, especially if you have some good biscuits and gravy and fixings that go with it. Okay, 2 different types of fixings there. See how I did that? Number 9. So what's called an intentional defective grantor trust. Let's dissect this. A grantor is the person who can create the trust. We already know what a trust is, but why would we intentionally defect something? Well, basically it's created to freeze some of the individual's assets for tax purposes. The individual then creates a problem in the trust document. They make a flaw. They give an error in the trust document that ensures that the individual, the grantor, must continue to pay taxes on the income. By doing so, it's going to reduce the value of the grantor's estate. So if the income's in the trust and you have to pay taxes on it, where are you going to get the money to pay the taxes? The idea being that we can use the estate proceeds or the estate assets to pay the taxes on a trust that's outside the estate, allowing the trust assets to continue to grow, receive full value without an erosion of taxes. So it's commonly referred to as an IDGT or an intentional defective grantor trust. That's a pretty common metric used in advanced tax planning. Another one is what's called a credit sheltered trust. This is number 10, a credit shelter trust. And what it does is allows married persons to avoid estate taxes by allowing the assets specified, so whatever's named in the trust document, to be transferred to the beneficiary, usually the grantor's children. So it allows the spouse to each maximize their personal estate tax exemption. Now, I've seen the credit shelter trust commonly used inside the will, the last will and testament, along with number 11 called the marital trust. You may hear it referred to as the AB trust, or in some states, the ABC trust, depending on the state taxes. Basically, instead of shifting the proceeds to the children or the grandchildren, as in the credit shelter trust, you're going to move the assets to the surviving heir. And thus, when the first spouse dies, they leave the assets in trust for the benefit of the second spouse. And those assets are not included in the second spouse's estate. So it's called a maritable trust or the AB trust. And so you could use a credit shelter trust in conjunction with an AB trust. Confused yet? Let's get out of the trust inside of a will and let's deal with a Q-tip. Yeah, like you clean your ear out with. It's called a qualified terminable interest property trust or a Q-tip trust. And this trust provides for the surviving spouse, but it allows the grantor to remain in control. So if you can remain in control, then is it an irrevocable or revocable trust? See how this all works together? It allows the grantor to remain in control of the distributions of the trust after the death of the surviving spouse. It's pretty amazing. It's often useful in second marriages or things where you're trying to prevent predatory type of marriages. We talked about the asset protection trust. The Q-tip can be used the same way. It has a little different provisions depending on the state you're involved in. The 13th type of trust is what's called the qualified person residence trust, or the QPERT. That's what we call it, the QPERT. Basically, it allows somebody to transfer their house to a trust and get it out of the estate. And you do that as a gift. Let's say you have a house that's worth $10 million. You can put that into a trust and it's considered a gift. And underneath the terms of the trust, you can live in that house for a certain number of years rent-free. I'm not going to get into more details on that, but basically a QPERT holds the house. Let's just keep it simple today. Number 14 is what's called a generation skipping trust. It does exactly what you think it does. It skips a generation. So if you, mom and dad, don't want to give money or assets to your kids, they say, well, I paid for them to go to college. They're super affluent. And I know people that deal with this. Then you can transfer it directly to your grandkids. You can skip a generation. Thus, it's called a generation skipping trust. Now, my favorite type of trust for advanced planning is the charitable type of trust. And there are many. You have the charitable remainder annuity trust, the CRAT, C-R-A-T, and basically allows you to place an asset into the trust, and the trust pays back a fixed amount each year. And then after you die, it goes to the charity. Well, Justin, why would you do that? We're trying to minimize taxes here. That's the whole idea behind it. So you can use a CRAT. You can use a CLAT, C-L-A-T, and that's a charitable lead annuity trust. So instead of the remainder getting paid to the charity, now you're in a lead trust. This is an irrevocable trust that provides income interest to a charity first. So you're leading with the charity. You're giving all the interest to the charity first. And then when you pass away, the passing assets go to the other beneficiaries. It's kind of reversed. You have a CRUT, C-R-U-T, and it's probably one of my favorite types of trust out there. It's an irrevocable trust that's created underneath the Internal Revenue Service's authority, and it distributes a fixed percentage of assets to the beneficiary. So I personally had a CRUT. I dissolved it. I have a couple of clients who have CRUTs. And let's say that you put $100,000 in there and you have 5% interest. If your calculation is right, you'll get 5% of the interest for the rest of your life. And then after your life or after a period of fixed terms, the assets are then transferred to the charity. Well, Justin, why in the world would you do that? Again, income and estate tax planning. It's an unbelievable tool. You have a CLUT, C-L-U-T, which is a charitable lead unit trust, which allows a donor to give a varying amount annually to the trust for a fixed term. And when the term is the remaining assets are given back to the donor or to the beneficiaries. So we just talked about the CRAT, the CLAT, the CRUT, the CLUT. You could even throw a NIM CRUT, N-I-M CRUT in there, which is a net income with makeup charitable remainder unit trust. That's another type of trust we can use. I didn't even throw it in my list. You have number 19, and this is perhaps one of the funniest names I've seen out there, called the shark fin. Yeah, like the fish that swims in the ocean. The shark fin charitable lead annuity trust. In a shark fin trust, it allows for small payments to be made into the charitable trust in the first few years, but then a very large payment must be made in the last year or two. So by increasing the payment over time, the assets in the trust have more time to grow. So it's called a shark fin trust. A lot of charitable type trusts there, friends. You see why you need a good attorney and why you need a really good planner? Number 20 is what's called an irrevocable life insurance trust. I mentioned this in my last episode that I personally have one of these. I had my trust buy a life insurance, and when I pass away, the trust will then shift the proceeds or the income to my kids and family, et cetera, et cetera. Number 21, some people would argue is not a trust, but a provision. It's actually technically a trust. It's called the Crummy Trust, named after the Crummy case. In 1968, there was a case, and basically it's a trust used to prevent a gift tax liability. It allows you to make contributions to the trust and provide notice to the beneficiaries. And by doing so, you're able to get deductions. You're able to create an outside the estate type of a trust. Crummy provisions appear on many different types of trusts. In fact, on my ILET, I have crummy provisions on my ILET. So there's a number of ways you can use a crummy, but it's called a crummy trust. Number 22 is called a build-up equity retirement trust. This is a fun trust. I've only seen it a couple times. Basically, a spouse makes a gift to the other spouse using the annual gift instead of the unlimited marital deduction. And by using it this way, the assets are outside the estate both for gift and estate taxes. They're exempt for both gift and estate taxes. It's called a build-up equity retirement trust. Now, here we go with some grantor type. Grantor retained unit trust, so a GRUT. And it's an irrevocable trust that allows a grantor to put assets in the trust, receive a variable amount of income during the trust term. So if it's a 20-year trust, they can receive income, and it can be fixed or it can vary for the life of the grantor. So you put the money in the trust and you get income back from it. You're not giving it to a charity, just you're going to give it to somebody else. A GRIT. Now, we're not talking about the grits that you eat with grits and eggs, okay? Which, by the way, I made some mean pot of grits the other day, and they were like, slap your mama good. A GRIT is a grantor retained income trust. Same concept as a GRUT, but in this case, the grantor places an asset in the trust, but they still retain the right to receive income from those assets for a period of time. So instead of getting annuity, they're able to get income out of it. Now, a GRAT, a grantor retained annuity trust, the grantor can make a large contribution to avoid gift taxes. Then he sets up an annuity, a GRAT, that basically allows an annuity payment for a fixed period of term. And then after that period of term, the remaining assets of the trust go to the beneficiaries as a gift. It's called a GRAT. Phew, is it complicated yet? Number 26 is what's called a dynasty trust. Now, there are some states where a dynasty trust is questionable. So this is where your attorney has to come into play. A dynasty trust is a type of irrevocable trust, and the grantor, using the law, sets strict rules on how the money is to be managed or distributed to the beneficiaries. I'm talking about ultra strict. The idea being that once it's funded, the grantor won't have any control of it, and they can't adjust the terms of it because it's irrevocable. The idea being is that neither can the future beneficiaries. So it allows wealthy individuals to leave money to generations, plural, without incurring estate taxes. So currently, underneath current law, depending on where you're at, you can put about $11.4 million into a dynasty trust. Okay.
You're listening to the Financially Simple Podcast. Show your support by subscribing to this and our other educational business channels at financiallysimple.com.
That is the more complex estate side or estate planning. Well, Justin, when should I start dealing with complex estate issues? I would say many times you're looking at income limits if you're trying to minimize income tax planning, or if you're running with major estates, major being you're above the current exemption amount. In that scenario, I would say probably north of $10 million, but then your state may have some issues there. For most small business owners, we're going to be worried about income taxes. And so you may use some of those trust provisions above that I mentioned in conjunction with your legal documents, or your LLCs, S corporations, C corporations, as a way to create really cool tax minimization strategies. Let's move on to some asset protection trust and other types of trust. So this is our number 27th. We're getting close to it. It's called a DAPT. A domestic asset protection trust. I mentioned this last time. Tennessee has an asset protection provision. There's a few other states out there, Alaska, Delaware, South Dakota, Nevada. I think Utah, but I may be wrong on that one off the top of my head, just because I was dealing with a case in Utah. In an asset protection trust, remember, like I said last episode, allows you to protect the money from creditors. That's the simplest way to deal with it. Number 28 is an offshore asset protection trust. Now, this is perhaps the strongest asset protection strategy there is. In fact, you typically see this on movies coming out of Hollywood. Basically, you create a trust in a non-domestic jurisdiction, and you allow assets to be transferred or conveyed to an offshore trust for the protection from seizures or judgments of creditors. Offshore money. Now, in the last episode, we talked about the Totten Trust, number 29. I'm not going to deal with that again. Number 30 is what's called the Land Trust, or some people call it the Illinois Land Trust. It originally came out of Illinois. The idea being is that this trust is allowed for nonprofit entities for conservation purposes. If you have a lot of farmland or a lot of timberland, you can use a land trust and have the trustee manage the ownership of it or maintain it for a piece of real property for the benefit of somebody else, for a beneficiary. So it's called a land trust. Now, this is one that you may not be aware of, but there's a thing called a gun trust, a gun trust. And the NFA gun trust allows the maker to acquire a Class 3 weapons holder. So you have to have a special license that the Bureau of Alcohol, Tobacco, and Firearms deals with this license. So you have to have a Class 3 weapons or other destructive devices, and basically you can transfer a gun to this trust and protect it and use that trust as the liability holders. There's a lot of rules on the gun trust. I'm not going to get into them all today. It's a trust that if you're an old country boy and you got a lot of firearms and you've got some weapons like semi-autos or some autos or some suppressors, things of that nature, you may want to look into a gun trust. There's reasons why you would want to do that. Number 32 is what's called an IRA trust. An IRA being an individual retirement account. You basically can establish a trust for the benefit of somebody, which protects your beneficiaries. So typically you see an IRA trust when you have minor children. This could be one of those trusts that the court sets up on your behalf. Remember, we talked about the trust that the court sets up. An IRA trust could be one of those. You're leaving an IRA to your spouse, and both of you are hit by that log truck, and now the money has to go to your minor kids. The court may come in and say, look, we're going to have you set up an IRA trust. This was the intent. We need to make sure it's protected. Now, whenever you're getting with special needs or elderly care, there's a few more trusts that we need to go over. Number 33 is what's called a third-party special needs trust or supplemental needs trust. We talked about this at detail with Jonathan Payton in our previous episodes, so I'm not going to dive into it too much, but the basic idea being is that a third party is going to set up a trust for the benefit of somebody who's special needs. And there's many, many, many reasons to do that. So we'll put a link in the show notes or inside the blog post to that particular podcast that we did with Jonathan Payton. 34 is a first party special needs trust. So we talked about the third party being someone else can set it up. A first party means that the person who has that particular ailment or disability can set it up, with the idea being that they can try to maximize their Social Security or their Medicaid benefit. Now, number 35 is called a Medicaid trust. It's an income-only trust. And what it does is it helps seniors avoid tax issues, potentially probate problems, when they're living in a nursing home and they die. It's a way that you can potentially protect the assets. Now, there's all sorts of clawback provisions here. This is where you're going to need to talk with a really good estate or end of life, somebody who may know Medicaid law. And this is a really good estate planning attorney's area specialty. Number 36 is what's called the Qualified Income Trust. I see it often referred to as the Miller Trust, which it's a good proper name. Basically, it protects the assets of an individual who has applied or is applying for Medicaid. So if they have too much money and they may not be eligible for Medicaid, you can use a QTIP, a Qualified Income Trust, as a potential way to help the individual become eligible for Medicaid. Now, I have personal ethical problems with that type of trust. I believe that we have money to use for ourselves. I don't think we should subrogate our responsibilities to the government. Personal opinion, feel free to make it yours because I'm right in this case. But nonetheless, there is a trust out there for that. 37 is a VA eligible trust. Again, you're placing money outside to allow for the Veterans Association to help you with in-home care, nursing care, etc. You also have number 38 called a Spousal Testamentary Special Needs Trust. Spousal Testamentary Special Needs Trust. So basically, you're mixing two different trusts together to basically help the surviving spouse be counted for Medicaid. Again, I have ethical problems with that particular idea, but it is out there nonetheless. Number 39 is what's called a pooled trust, and it's designed to help disabled people qualified for Medicaid. A pooled trust is run by a nonprofit organization and allows individuals to basically put their excess money over the eligible limits into a trust, which then is going to pay the disabled person's additional bills in addition to what Medicaid is going to pay. So that's number 39. That's a pooled trust. If you're still with me at this point and you've listened to all 39 trusts, you deserve a crown in heaven because that is complex information. Maybe you thought it was intriguing. Maybe you're dealing with what some clients recently are dealing with and they're saying, hey, Justin, we need some help. I actually had a conversation today with an individual who tried to hire an estate planning attorney, and the estate attorney didn't know some of these basic instruments. They didn't know. It just wasn't their area. They knew real estate laws, and they knew real estate as related to estate, but they didn't realize how all these different trust documents fit together to help structure a prudent financial plan. If that's you, and you're like, man, Justin, I need some help, reach out to us. You can reach us at info@financiallysimple.com and say, hey, I want to chat with you. I need help. I need some good business planning. I need some good estate planning. I need some good financial planning. Our processes are here to help you drive as much revenue as you desire, as you can handle, as your body can take. Trust me, it's hard. I've given so much information in this episode that I really want you to take a look at it on our blog, financiallysimple.com. And while you're there, be sure you sign up for our newsletter. An episode like today kind of magnifies the need for professionals. And I break down these concepts and doing some of the best writing I do inside our newsletter at financiallysimple.com. I say it every week, life is hard. Life is good and life can be frustrating. Money doesn't have to be. Estate doesn't have to be. Trust doesn't have to be. Let's continue to make our lives at least financially simple. Hey, y'all go out and make it a great day.
You've been listening to the Financially Simple podcast. For more business and personal financial help and information, head over to financiallysimple.com today.